Hello, welcome to Legal Action. My name is David Siegel, alongside Jesse Barrientos, my co-host, and today we're going to be talking about divorce and family law. Jesse, welcome to the show.
Thanks, Dave.
And Jesse, we have a special guest, a canine, and in typical divorce cases, sometimes a canine is something that couples fight about.
Absolutely. We could probably even start off with that.
It's like a little child.
It's like a child. But contrary to popular belief, you can't take the deduction, even though federal prison is probably infinitely better to state prison. However, we do have issues when pets are involved.
Yeah, it's a piece of property under the court's eyes. It's not a child.
Right. They call it a chattel, which is property. Exactly right.
But there are sometimes extravagant custody and visitation arrangements for dogs.
I actually had a case not too long ago where the wife and the husband were living separately. The wife was in a place where she couldn't have pets.
Sure.
And there were, I think, 2 or 3. And so she wanted visitation, and we had visitation for the dogs. It really, when it comes down to the court size, again, they just view it as chattel, as property and all that. But we had that until she was in a place where she could have pets, and then they were transferred. But boy, that's just that's sometimes just looking for trouble. Sometimes it gives another spouse an opportunity just to be physically present with that other person.
Yeah. Well, unfortunately, Jesse, we have to talk about divorce and family law because it is so prevalent, unfortunately, in our society. And I wanted to talk to you briefly to start about the grounds for divorce. People get hung up on the grounds: adultery, mental cruelty, irreconcilable differences. And they really don't understand how to prove those grounds or when those grounds should be appropriately used. So can you talk about grounds from the most common to the most uncommon?
Sure. Illinois is a no-fault state, which means that...
But it was his fault.
Well, it's always somebody's fault.
What does that mean, no fault? Let's talk about that. That's important.
And we're gonna get to that. But Illinois has it's no-fault state and it has a no-fault ground, which is irreconcilable differences. It's really a ground, but it's a no-fault ground. And with irreconcilable differences, you're saying that we just can't get along. We've tried to get back together. We've tried to reconcile, but it's fruitless and futile. It's not going to work, and it's not in the best interest of the parties or the family that the parties get back together. With irreconcilable differences, you have to have been living separate and apart for a continuous period in excess of 2 years. However, the 2-year period can be waived by affidavit and stipulation, but 6 months of that 2 years cannot.
Okay.
When they talk about living separate and apart, it doesn't necessarily mean not living in the same house, because a lot of times people will still live in the same house because they can't afford to go anyplace else, and they can't afford to have another whole residence and all that. And so what happens is one person maybe will go to the guest bedroom or go to the couch, or even they may even sleep in the same bed together, but they're more like roommates. They are no longer intimate, and they're no longer really living together as a husband and a wife. And it's been construed to mean sometimes that they haven't been together that way.
So if you're not functioning properly as husband and wife, and you've been living like this for at least 6 months, and you both agree to reduce the 2-year waiting period down to the 6 months for irreconcilable differences, you can utilize those grounds.
That's correct, unless you've been separate and apart that way for in excess of 2 years. Then,
and we see that on a lot of cases, and especially desertion cases.
Right, and that's another one, desertion, another ground that's really I don't think really too often used. And basically, what that is that the other person, the other spouse, has left for a period of a year, and you don't know their whereabouts. That they haven't said anything. They just went for a pack of cigarettes or a gallon of milk, and they're gone.
And importantly, you did nothing to provoke or cause them to leave.
Right.
Okay. Let's talk about the big ones that people have hard times with: mental cruelty and physical cruelty. What are those grounds all about, and how do you prove them?
Sure. Mental and physical cruelty. And typically when we do a petition, because we don't know what's going to happen, nobody's going to agree and say that I've been mentally or physically cruel. And we do irreconcilable differences as an alternative ground. But mental and physical cruelty, let's start with physical cruelty. Well, I think that's kind of explanatory. Physical, that means that, hey, I've abused you physically during the course of the marriage. And that could mean that I beat you or I've slapped you or anything else. We have a whole another, it's probably another show. We can talk about orders of protection and domestic violence issues, and that transcends and gets into, crosses over the boundaries of civil and criminal kind of court. You know, if somebody hit a spouse, you could certainly be charged with domestic battery, which is a crime. And so if you get into other things, I mean, you could get, so physical cruelty kind of would refer to that kind of physical aspects, and you would prove it by your testimony.
What about the less obvious one where it's a little bit tougher to prove, and that being extreme and repeated mental cruelty? What is that all about? What does it entail?
Mental cruelty is one of those interesting grounds. I mean, I think that people can prove, I think, to be quite honest, I think that pretty much that we've all experienced mental cruelty to some extent or another. And again, that also has to be without cause or provocation on the part of the other spouse. And so those could be things where I berate you and I tell you that you're no good and I tell you that you're useless and I don't appreciate the domestic things that you've done around the house. You've watched over the kids, you've taken care of and cleaned the house and cooked the meals, and I berate you. I also think, and we'll talk about this other ground, adultery. I mean, I think that if you committed adultery, and I know about this, right, and you flaunted it in front of me, I think that that certainly would be a form of mental cruelty.
Right. How about some of the lesser ones? Habitual drunkenness.
I think that's pretty much self-explanatory there.
What about a communicable disease?
Well, that crosses into, or may or may not cross into the grounds of adultery, right? But if you didn't have a communicable disease when we got married, and now you have one, you know, Dave, I don't know what to tell you, right? Obviously, right, something happens there. So there's an interplay, but for the most part, and we'll even talk about adultery, sometimes people feel so emotionally damaged, and they're hurting, and they're mad, and you go through all different kinds of steps when you find out about something like that they want that to be in the petition. Generally, I try to, again, we've talked about the mental and physical cruelty, and I think, like I said, in terms of adultery, that's a form of that. When you get into those things, sometimes they really want it in the petition because that's what happened. You cheated on me, and you know, that's the truth, that's what happened. That's what I want to go in the petition.
Well, I think it's important for our viewers to take away this fact, and that is that marital fault has no consequence in terms of division of property, allocation of debt, who gets what, how, and why. It might be in the documents that one party committed adultery, and it might be you know, kind of a touche kind of thing or an anger thing, but the court does not care in terms of how they decide the case.
That's true. I've had some consultations, and I could tell you where somebody had proof, and when I say proof, I mean proof.
Photographic proof.
Well, I don't know, maybe we can talk a little bit, I probably can't talk that graphically about that. No, he had physical evidence.
Okay.
And so, and had it saved, and anyway.
Does he know Linda Tripp?
People have a hard time.
Monica Lewinsky?
I'm not sure. You know, we didn't ask.
All right, let's move on.
You never
here.
can tell. But basically, that's right. He had a hard time kind of grasping and understanding that didn't make any kind of a deal whatsoever. Now, what does have an impact would be the lifestyle of that person. If
relating to children.
If children are involved, that's exactly right. And so that certainly would have an effect.
And that makes sense because conduct can make someone unfit in certain cases if it's going out and carousing all night or
could be a consideration.
Habitual drunkenness or neglect and things like that. But overall, you just need grounds to get into court to be eligible for a divorce. So let's say we get the grounds set. Let's say we're going with irreconcilable differences, the most simple. We now have to get into some other things, and that's the division of property and the allocation of debt. Can you talk to that a little bit?
Sure. Well, again, it's dividing up the pie. Generally speaking, anything acquired during the course of the marriage is marital property. Any debts acquired are marital debt that's subject to equitable distribution. And I say generally because certain types of things, there is non-marital property, non-marital his and non-marital hers. Those would be things that were acquired during the course of the marriage, but are not part of the marital estate. We're thinking of things, again, putting everything in this pot here that you acquired to the marriage. Now, an example of that would be a gift. If, for example, I gave, well, let's talk about the wedding rings, because that's a great example. I want that wedding ring back. I gave it to her, and you know it was $50,000 or $28,000, is 1 carat, whatever. You know, it was my great grandma's wedding ring. You're kind of out of luck. It was a gift, and the elements of a gift are, one, that I have the donative intent to give you the gift. that there's actual or constructive delivery. Actually, delivery would be me giving it to you, me putting it on your finger, right? Constructive delivery would be, if we bought a house, obviously I can't pick up the house and give it to you unless it's an itty-bitty house, right? So I give you the keys. Same thing with the car. That would be constructive.
Well, let's contrast that with an engagement ring. That's a different situation.
Hang on, right. Well, let's get back here. And then acceptance, right? An engagement ring, and there's a couple different ways to look at that too.
Promise to marry.
Promise to marry. However, though, Dave, when you look at it, it's still a gift. Now,
a revocable gift.
Maybe from my experience, and I've been doing this, I don't know, maybe I think a little over 19 years. We've always had the issue where people would argue over the wedding rings and those kind of things. The engagement ring, I suppose, if there was an engagement, well, but here's the thing: if it's an engagement and the parties didn't get married, then that comes into a whole other idea. It's really
it's a
not
breach.
Right. It's really not. It goes into contract law. It's really not in the kind of arena here of marriage dissolution type of thing. So it's different, but it's a very interesting deal. But I think primarily, if somebody just got engaged and then they call it quits, and it was a very, very expensive ring, and it really shouldn't matter how much it costs. But
right.
Yeah, so that's a little bit different because you're not married. And it wasn't acquired during the course of marriage. It's a gift, true, promise to marry, and then you have to get into all kinds of things on what kind of happened and what the reason and what the intent and motives were and that kind of stuff. But when you get into this situation, when you're talking about that kind of property and you're talking about your rings, that's non-marital because it was acquired during the marriage, but it was a gift. Let's take an inheritance. Let's say that we're married, and well, I think we can only do that in California. I'm not sure, maybe a couple other states, but okay, parties are married and I get an inheritance, and Uncle Joe leaves me $5 million. Okay, guess what? As long as I don't what they call commingle it, it's not. They have a fancy name. It's called transmutation. Of basically, the non-marital property loses its identity when it becomes commingled, or when I put it in a joint account, or when we buy a house together with it, and our names are on the house, and there's other things that can happen that would cause it to be transmuted to marital property. But as long as I keep it separate, guess what? It's non-marital. Now, let's take an example of a house. Let's say I inherited a house.
Okay.
I still have to pay taxes on the house. I have to maybe do some upkeep to that other house. And as long as I haven't commingled it, and as long as it's always in my name, I am still spending now marital assets on a non-marital asset of mine. So at the conclusion, when we're dividing the pie here, we're going to want that money to come back to the marital estate. So let's say I can track it. I've had it. We've been married for 5 years, and I've paid $5,000 worth of taxes. Okay, that's easy to figure out. You got $25,000 plus whatever else, whatever improvements I've made. Okay, now that money comes back to the marital estate, but to be divided at whatever percentage is equitable and fair. And so basically, it's a contribution back to the marital estate. So, when people think about those things, that's why I said, generally speaking, anything acquired is marital during the course of marriage.
And what about marital debt? How does the court try and allocate marital debt?
It kind of works that way, the same kind of way, in terms of, we see what the debt is. Even if the debt was used for a non-marital purpose, and now we're getting into another fancy term of art, is what they're calling dissipation. We can have dissipation if I take marital money. Let's say we have a joint account here, and I've taken $50,000 out of it, and I went with my girlfriend.
Here we go with the adultery again.
We go with the adultery again, to the Bahamas or wherever, and and I used it very clearly for a non-marital purpose. Then, if the other side filed what they call a notice of intent to claim dissipation, then now it's incumbent upon me to be able to trace that money and to prove and to show exactly where it was spent and everything else. The same, I think, you can do and have that theory with respect to the debts. If I charged up a debt because I know we're on the outs here, and I go someplace and charge something up that's not for a marital purpose to increase the debt so that I get a bigger piece of pie, or so that you have to pay some of it, then they could allocate the entire thing to me. But generally, what they're going to do is they're going to divide it in such a way as to equalize the situation for the parties, the income and the debt. It depends upon how long the marriage was and other factors as well.
Let's talk about spousal support, now known as maintenance, formerly known as alimony. How is that determined? How is it paid? How much? What duration? What does the court look to? What are the factors?
It really depends. They look at the duration of the marriage. They look at the lifestyle of the parties that they had during the course of the marriage, which means, for example, if we went on vacation 12 times a year and we went on the yacht and we did all these kind of things, then the other party's entitled to live at the level of life that they had.
It sounds like the Jesse Variante's life.
Oh, I don't know about that, Dave. I don't have a yacht. And I'm pretty sure I don't take 12 vacations a year. That would be nice. It really would be. Maybe 6, I don't know, but you can't tell for sure. So they look at that. They look at the income and the assets of both of the parties, and they look at whether or not one party has contributed to the other party's education and their vocational success. So let's say that during the marriage, I worked a couple of jobs and my wife went to school, and now she's got her master's and she's making $200,000 a year and I'm making $100,000. They're going to look at that too, because that's an aspect, because during the course of marriage, had it not been for that situation or that opportunity that you had, you wouldn't be in the position that you are. So they're going to look at that. They're going to look at the duration of the marriage, and that's going to determine if maintenance is appropriate, how much maintenance is going to be paid. Maintenance is appropriate. They have what they call rehabilitative maintenance. In other words, it's going to allow the other person to get a chance to be rehabilitated, to be able to go out there and get skills, to be employable, to make a living in order to sustain himself or herself. Because a lot of times, one of the parties is the one that stays home and takes care of the children, takes care of the pets, takes care of the house, and does the cooking, does the shopping, or marketing, as other people like to refer to, right? Mm-hmm. And so that person has to have an opportunity. They've been out of the job market for a long time sometimes, and so they need to acquire skills in order to make them employable at a certain level. And there's also maintenance that you have, which would be temporary maintenance, which would be for a specific amount of time that would be reviewable, dependent, again, upon the duration of the marriage and dependent upon who's making what. So in other words, we're trying to equalize out that income. So maybe it's a situation where you have to pay, I'm just going to pull a figure out of the air, $1,000 a month, so that our incomes are equalized. And then so, depending upon the course of the marriage, it might be 2 years, 3 years, 4 years, however, where it's reviewable again. And then party can file a petition to come back in to extend that maintenance. And what they're going to look at, and it depends on how the judgment is drafted and all that kind of stuff, but what they're going to really look at is, what have I done during this course of time to improve my situation? If I've done absolutely nothing, okay, even though, hey, I still am in need of the maintenance and I've done nothing to improve my situation, then chances are it's going to be more difficult for me to get that to continue. Okay. They have permanent maintenance, which is just what it sounds, but nothing is really truly permanent, because if there's a substantial change in circumstances of the payor, that's the person who's paying the maintenance, or the payee, that's the person who's receiving it, then they can come into court on a motion, and the court's going to hear that and make their determination based upon that unique situation. Yeah,
there's also statutory termination events as to maintenance.
Right, but before we get there, I want to talk about one more thing, which is important.
What would that be?
I want to talk about Isabella, Dave.
In terms of maintenance?
In terms of
low maintenance.
Low maintenance, are you sure?
Very low maintenance.
Okay.
As you can see.
I don't know about that.
This is low maintenance.
Yeah. They have maintenance in gross, which is a sum certain.
A dollar figure.
A dollar figure. So let's say it's $100,000, and it's payable in installments. Now, it's good and it's bad. It's got two edges to that sword, which means that the termination events that we're going to talk about don't apply necessarily, because, again, this is what you're paying. You're just paying it in installments. And then maintenance is it. That's it. There's no coming in. There's no getting it modified. We're done.
Non-modifiable.
Non-modifiable. And so the danger for that, for the payer, the guy who's paying it, is twofold. Number one, what if my position changes and I can't afford to pay? I've got to pay it. I mean, that's what it is. what if one of those termination events kicks in when normally I wouldn't be required to pay it? Well, guess what? I still have to pay it. Okay.
But you do get the tax deduction as the payor, and the recipient has to pay tax on that maintenance and gross.
That's absolutely right, and that is.
So you get that benefit.
You get that benefit
as a payor.
As a payor. Well, and as a payee, you have to claim that on your taxes,
right.
which is something that you don't get with child support. Sometimes what they'll do is they'll lump child support and maintenance together and call it unallocated support. And so typically that is the payer is able to get a tax break and write that off and take that deduction, and the payee has to claim that on their taxes. And sometimes that happens in order that the payor can pay the payee. She can get a higher amount of support because the calculations that go into the break that he gets kind of boosts his income up a little bit. And there's what they call a fin plan. It's a program that allows attorneys to be able to see exactly what the consequences are of putting different numbers in different columns.
Right, and you're talking about things that happen in more of the complicated, high income, high net worth type of cases, correct?
That's right. But you can have that really in any case. It's a little bit more simple. But yeah, typically you have somebody they're really close. They make, really close in what they're making with each other, and so you don't have that issue.
Okay.
And
Well, so far we've talked about division of property, allocation of debt, and spousal support.
Right.
Let's talk about the most important thing that we see in a lot of these cases, and that is children and the issues relating to children, that being custody, support, and visitation. Let's knock those off one at a time.
Custody, support, visitation. But you know what? I don't want to disappoint our viewers. We're talking about termination events, and I want to make sure that we don't forget to tell them exactly what that is for maintenance.
Okay, what are those?
And unless it's agreed otherwise, it is going to be the death of the payor, the death of the payee. It's going to be someone living on a continuing conjugal basis, which means that the person who's receiving it with somebody else that's going to be able to receive that. It's that other person's remarriage.
Sure.
And so, I mean, when you think about it, it makes sense. And the last one would be completion of whatever amount of payments. If it's payments, if it's maintenance and gross, or if it's reviewable within a certain amount of time. So the amount of those payments, whether or not it's 2 years, 3 years, whatever, unless somebody comes in on a motion to extend it.
Okay. We just have a short window of time, but I do want to cover child custody support and visitation briefly. Let's start with child custody.
Child custody, a lot of questions that people ask, they talk about, there's a couple different kinds. There's joint custody and there is sole custody. Sole custody means that the non-custodial parent, the parent who does not have physical possession of the children most of the time, does not have a say-so in the upbringing of the child, in the day-to-day decisions, in the medical arena, in the schooling, and in the religious raising of the child. They do not. Joint custody means the opposite of that the non-custodial parent does have the ability to have an input in those types of situations. And with joint custody, generally what happens is you have the custodial parent, the residential parent is really what they call it, or custodial, that has the children most of the time, and then the other spouse, the non-residential parent, has visitation. Typically, that is on alternate weekends, maybe a time or two during the week, and then alternating holidays as well. There's one more hybrid, which is called joint residential custody, and that means basically where the parties really have the children kind of half of the time here and half the time there. That's very rare, and that's only good for the child in very, very unique situations, but that is another type. So basically, both parties are residential parents.
The courts also don't like to split up children.
They don't like to split up children, absolutely not, because that's everything, and the concern is for, as it should be, is for the child. And we're not going to do this because it's more convenient for the parents, although that's what happens all the time. The main focus and main concern should be of the best interest of the child. We talked about visitation. We have those visitation scenarios. We also have sometimes supervised visitation, and that would be in a case where there is a worry or a danger that the child being left alone with the other parent. And that could cover a whole bunch of situations. It could be somebody who has mental issues. It could be somebody who doesn't have the skill and able to watch the kid, has never done that. And there's also, no overnight visitation. And again, there could be a whole bunch of different concerns on that. We can go on. It could come down to the living quarters are not suitable, or could be that the person doesn't have living quarters. If somebody's living out of their car, guess what? You're probably not going to get, overnight you're probably going to get, supervised,
Right.
maybe.
Now, the person who has custody, the day-to-day physical custody of the child or children, is entitled to child support under the law. How is child support figured?
What they look at, it depends upon how many children you have. If it's one child, it's 20% of your net. If it's two, it's 28. If it's three, it's 32. What they're going to look at, and what is important, is what net income is defined. In the statute, the Illinois Dissolution
Illinois Marriage and Dissolution of Marriage Act.
Has a statutory scheme where it sets out what the definition of net income is. And what they're going to look at, they're going to let you take out your federal taxes, they're going to let you take out your state taxes and Medicare and all that. They're going to let you take things, for example, for union dues. They're going to let you take out mandatory pension. A lot of times, if you're a federal employee, you don't pay regular taxes. You have your mandatory pension and you do pay Medicare, and those things, come out. Again, union dues, your expenses for insurance, for health insurance, are going to come out of that as well. And once we've taken all of those things out, we're going to find out what your net income is. And then we're going to multiply that by those numbers to determine what the amount is. Now, that's what is the statutory guideline of support. Now, it can go above that amount or below that amount depending upon the situation.
Okay.
And so it just depends. If it's a special needs child, it could be more. If the child doesn't need that much, or the other person, or something is figured into the property settlement, like I give you all the equity in the house, that would be a reason to deviate and go downwards.
Okay. Let's talk about post-high school educational expenses. Is it true that either party can come into court and ask for a contribution based on their income and their assets?
That's right, and the Act does have a scheme for that too. And basically, either party can petition. It's very unique that the children of divorced parents can have their college education paid for by their parents, whereas the children of married parents don't have such a right. And it's not the child that comes in, it's one of the parent or the other to contribute toward that. They want their children to go to college, and that's great. Every child should have a great education, as good as you can give them. And so one child, typically one person is paying, the other person is not. So they bring a petition for contribution. They look at that person, the husband's income and expense. They look at the wife's, and they look at the child. They also expect these days the child to contribute, and that's either by doing grants or getting loans or by working a job.
What if the child can get into Harvard? Are the parents going to be required to support that child through that kind of collegiate experience?
They do not have to pay that. Generally, the marriage, the agreement will specify what the conditions are, and generally limited to what a state college is, like U of I, University of Illinois. However, if your child can get into Harvard and there's any way for you to do it, or any other school, you want him or her to have the greatest education possible. And boy, I tell you, I would do everything I could to make that happen.
Okay, that sounds great, Jesse.
But I graduated from Loyola. And then
Loyola University in Chicago, which is a fine school.
And then John Marshall Law School, absolutely.
Right, and I have that in common with you, the John Marshall part. Okay, so we talked about division of property, allocation of debt. We talked about spousal support. We talked about child support. We talked about custody support, visitation, educational expenses. Any final thoughts in the divorce arena that you want to leave our viewers with?
I want to say that there's so much more to talk about, but you know what? Basically, everything's about the best interest of your child and your relationship. You need to talk through everything. Communication is very important.
Absolutely. Jesse, thanks for being a part of the show today.
Thanks, Dave.
We have talked about divorce and family law. On behalf of Jesse Barrientos, my name is Dave Siegel, and Isabella, we'll see you next time on Legal Action. Take care.